including in Macau and Taipei as well, that we have met a lot of lawyers and those cryptographers, tech people, that they're like, yeah, I mean, we should come up with something that protect, right, the security, the privacy of internet users and consumers in general, about their consumer rights, about their political rights, civil rights as well. But then there's a question of like, we found that there are a lot of breaches. There's which the law actually doesn't update it enough to cover those breaches. Because I mean, in according to the law, those kind of breaches, to our understanding, it's not actually a breach, according to the law. Or there are some standards that like coded in the law that like, this is the thing that you should do 1, 2, 3, in order to protect the data of the citizen. But those criteria, it's no longer relevant. Some of the things that works in the past, right, 10 years ago, those like technological measures, it's no longer work like nowadays, because the assumption, right, that used to pass the law 10 years ago is no longer true. Those assumptions is no longer true, right? For example, when we're talking about the length of the encryption key, right? It used to be suggested like, okay, it should be this X long, right? Because we think that like the computing power back then 10 years ago, if you are going to crack this, it's going to take like 200 years time, which is in terms of personal data, it's not that relevant because the average life span of human is less than 200 years. So given that this encryption key, it's possible to protect someone for 200 years, it's good enough, right? But then later we found that like with the advancement in algorithms, in advancement in computing power, together with other techniques, it shortened the time 200 years into say like 10 or 20 years, which is in this case, well, it's still a long time, but it's shorter than human lifespan. So in terms of the protection of the personal data, maybe it's not that no longer good enough. So I think this is actually, I think, like the key question that why we have the panel today, to talking about when we're talking or when going to like code something or in terms of standards as well, or the law itself as well, how we going to think about this to make the regulation actually future-proof. So I think probably we can start with Jakapong first. I will introduce you. Maybe I'll let each of you introduce yourself first, and then back to Jakapong to give us a technical background of how this possible in terms of like the technicalities, right? Maybe introduce yourself first.
Jakapong Natvichai from Chiang Mai University, from the north of Thailand. My background is computer science, and I'm working on the data privacy in terms of the technical part of that, not policy, but I can share with you about my thought about that as well. Please.
Okay, good afternoon. I'm Wei Zhong Huang from APrIGF Industrial Technology Research Institute, and my major job is the development of big data and artificial intelligence technology. And in this year, we also work with governments, also industry, to set up the data privacy framework, try to address the requirement that when government or enterprise try to release data to third party, then they make to do some kind of de-identification of the data, make sure that the data cannot be reversed to the link to the personal identities. And we develop some, follow the international standard, we develop some mechanism and some technology, and I will have some kind of brief of our framework later. Thank you.
So, Mr. Jakapong, please.
Okay. Actually, the plan is that to have Dr. Thitirat to go first with the overview, but I will show you my background work first in terms of technical, right? If you think about the topic of obscure the data or preventing the re-identification of the data, or sometimes we call it data masking, right? To do that. Okay, I show you. This is the outline of the I mean the guideline from Korea. This one, and I think that anybody from Korea? Not Korea. You, right? Korea. Okay, because I look at this one as an example. This is the guideline to de-identification of personal data, right? In that guideline, it's very, I think it's very well designed. They are composed of 4 steps before we can release the data, or we can disclose the data to the public for other users. The idea may be very not very safe if we think about customer point of view or just citizen point of view. It means that after some organization trying to collect our data by any means, using some of their services, right? You, for example, one of the data that now being used in Thailand quite a lot is the trajectory data from the cell phones. Let's say that you all have like cell phones in your hand, and when you commute to somewhere else, right? Usually the location and the tracking you can be tracked by the provider, and of course it's not like 5 meters or 10 meters, but at least you can be located like in cell site, and we can track somehow to which location that you can go. Actually, that kind of data shouldn't be released, right? I mean, in point of regulation and in the viewpoint of laws. However, there could be some services that can be improved, I mean, for human life to use this kind of data. We compute a lot to trying to put more antenna to the system of the cellular system to improve the quality of the signal. Or maybe we can, some of the maybe partners of the telco can put some of the merchandise or to make people's life a bit better somehow. Usually when you're trying to get those kind of data, there could be some regulation involved, right? However, the data to be released has to be somehow remove firstly the ID, right? Identification part, for example, right? Name, maybe citizen ID, or maybe part of like date of birth or something like that, right? So this kind of framework in Korea that I just found is composed of 4 steps. I think it's very common. That okay, the first one, they were trying to do the prelim review whether this data to be released is contain the ID or contain personal information. Some are not, but some may have something related to those kind of data. And in the second step, they're going to do the de-identification. Of course, the name will be removed, the ID will be removed, and some other specific for any people will be removed, right? And then they have, in the third step, that they're going to have a bit of further de-identification. In Korea guideline, they even add what they call the K anonymity, this one, right? But actually, that's very standard kind of algorithm to protect the data from being re-identification again. And the fourth step, of course, they can release those kind of data. That's the general view of the procedure of that. However, if you are familiar with this picture, and anyone in the room have seen this picture before, I think, right, very interesting. This one has been used a lot to show that the data releases are not that safe anymore. This is from Sweeney, professor in I think same year at that time. At that time, 2002, right? The scenario is like this. Suppose that you go to some hospital, right? And of course, all the data can be recorded, right? On the left-hand side, they have everything: visit, date, diagnostic, procedure, medication, and total charge, right? And if you think about that, that's very, very private data that should be hidden, or maybe should be recorded at only the hospital, right? But this kind of data are very, very commonly requested from maybe researchers, maybe even medical doctors, or maybe someone else that would like to use those data for, maybe public good, right? And then they say that, okay, to release this kind of data without any ID could be safe. However, it's not longer the case, right? Because we are in the world that everybody trying to collect the data. People may have external sources of data outside the left-hand side. For example, in this case, Sweeney showed that she can obtain voter list for democracy election, right? And she can overlap and cross-examine the data to get someone to do the ID again. In this case, she's trying to re-identify William Well, who is the mayor of that area, right? From that data, suppose that the intruder knows that this guy admitted to the hospital at that time, and maybe we would like to know what is the result of that diagnosis result, right? So we know that from the area. Okay, the area is Massachusetts, right? And there were only 6 people had the same date of birth as this guy, right? And from 6 people, we can narrow down to only 3 because of the gender, right? And then from 3, only 1 that matched the zip code. So it means that it's very easy to get one data, which seems to be safe, no ID, and then to do the cross-examine with other kind of data outside, and to get to know the sensitive data inside. Right. We can mix it. That's the idea. So to remove from this article, it seems that only to remove the ID maybe is not enough, right? So that's why people invent the thing called K-anonymity at that time. Almost 20 years ago, right? And for example, from this part, right, we can remove the name. This is really a bit oversimplified. We remove the name, and then we are left only sex and age, right? So we can somehow to do data masking on the age to make it as a range, not exact age, to trying to obscure the data from being discovered again. That's the idea for the K anonymity. In this case, the K is a number of the people that can be mixed together without any way to re-identify again. This one, K is 2, because 2 people can be somehow put together and you cannot re-identify. That's the idea, right? And of course, there are, even though we're trying to do the data protection like this, it seems to be safe, but actually there are more problems to this kind of situation. For example, okay. What is that? Okay. Let's think about it. I suppose that we're trying to look at this data first, right? And if you look at it, it seems to be okay, right? Because if we know someone is male at age somewhere at this range, right? We don't know about that disease. I mean, we can hide 1 from 2, right? It seems to be safe, right? But for example, if we do multiple release of the data, we update the data, we put more data, right? We put more here, right? And we're trying to do data masking again to make the data something like this, right? If you look at it, we have male and 63 and male and 80. There will be somewhere like this, right? And we mix that disease into something like this. It seems to be safe, right? It seems to be safe because we can hide someone in a group of 4. However, if we put more data like this, in the third release of the data, we put more data, right? And we do data masking again. It seems to be okay. But if you think about it, to do multiple releases of the data from all the time, I mean, just add the data, we can still cross-examine to re-identify the data again. For example, if you look at Jack, right? Suppose that we know that he admitted to the hospital at this time, the second release of the data. If we look at it, okay, he will be somewhere around here, right? But we don't know which one of the 4 that he can be, right? But however, if we look at these 2 data sets, right, we will know somehow that he maybe don't have heart disease, he may don't have flu, so he can be somewhere around here. Right, 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 right. However, we still can see that we are actually not sure, right, that which disease that he can have, right? But if you look at the third release of the data again, where could Jack be, right? If you compare, we can compare again, and we can know that which disease that he can have. So this is only the issue that can be happen. I mean, because we always collect the data. However, we still somehow trying to protect the data. But from if the time goes right, and we can see that maybe if someone trying to attack, trying to re-identify, it can be possible somehow if we are not aware about that. Or I show you another case and I pass to the next person like this. This is what we call the trajectory data. Suppose that if we're trying to compute which clinic in a hospital which needs upgrade, I mean in terms of infrastructure, put more nurses and more doctors, right? Maybe we're trying to improve the route time after the patient get first diagnosis until they discharged from the hospital. So what we can have the data, right, start from this A clinic, then to D clinic, and diagnosis. It seems to be safe, but what if we are having an attacker knows about the trajectory of that patient? I know that this guy going to a hospital this morning, and I try to follow him, right? And we know that, okay, he enter into this room and go into another room. And if we try to get this kind of data, we can somehow have the diagnosis result if this kind of data are released. But I'm not talking that we shouldn't use the data. To collect the data and to utilize the data is somehow maybe it can be good thing for people, but to protect the data is something else that we have to do. Okay, so I pass to.
Thanks a lot. So this is kind of technical background of like how things can go wrong sometimes, right? We're back to the big picture a little bit. We having now Ajahn Titi Rat, right? She's a lecturer at Faculty of Law at Thammasat University. And probably we have more Siming and Ahmed. Do you like to join us? No, not now, right? Okay. She will give us an overview of like the international framework as well. Also, like probably going to talk a little bit of the European Union data protection law, right? Okay. ขอสไลด์ที่1ครับโอเคครับ So I hand you over to Tijirat. Tijirat, can you use that mic?
Okay, so good afternoon. Thank you for inviting me to this event. So yes, I think we have seen the from the research, the architecture side, how data can be de-identified, de-anonymized, and also make it related to identifiable person in reality. So let me start with this chart, this picture. I think many of you might be familiar with this one. So this is one of very famous diagram from Professor Laurent Lessig and the code version 2.0. So if you think about what can control individual behaviors in the society, usually we think about law. But Professor Lessig tried to convince us that not only law, actually there are many other rules, there are many other norms, many other factors that actually control the behavior of individuals. So law create artificial constraints to impose or to control individuals in the society. But also we have the social norm, which create cultural constraints. So you cannot, for example, in Thailand, you cannot pass by the elders without greeting them, something like that. Yeah, hello. Okay, and also the market, which create economic incentives. And now what the law today focus about is actually about the architecture. So the architecture or technology control physical or structural, create physical or structural constraints. And that come to the next one, the next, oh, it's fine, okay. The next diagram, that actually the law today is not trying to control directly the individual behavior, but also control the other factors that will let individual behave in the way that state think it fits or it's suitable or desirable. Okay, so we see that law does not only regulate us directly, but it regulates many other things to make us follow the path that the law aim to achieve. Okay, so let's see some examples that is quite, I think this is example that easy one that will relate to our daily life. For example, the technique that the law use in general, it imposes general goals for everyone. For example, in traffic traffic law, we have the law imposing the goal of safe driving, and we have discretion. We, the driver, we have discretion how to drive safely. So that can be subject to individual interpretation of this safe driving. And then we also have the law that set some more specific rule, prohibitive or instructive rules of desirable behavior, such as if you want to drive safely in a certain location, for example, on the highway, you should not exceed the speed of 80 km per hour, something like that. So this is very specific. So you have very little discretion to interpret this kind of law, right? Then the third one, the law that try to change structure. So I mean by saying law here, I mean the state power, trying to change the structure or the architecture of that environment. So that will control directly the behavior directly, such as the state might build washboard road that will slow down the speed of the car. So even though there is the law saying that you should not exceed the speed of 80 km per hour, still some violate such law, right? But if you set these some architecture, change some architecture of the road. So the car must physically follow that instruction. But in many situations, state cannot change the architecture directly because the architecture or the technology are not in hands of state. So they are in control by private company and many other institutions. So here, the legal technique today, the law trying to oblige private company to impose certain structure, such as imposing driving control function in car engine. So this might happen in the future soon, that if you want to change the lane, you need to put the blinker on. So right now, the law allow some company to do that, but in the future, the law might impose every car company to do that. Okay, so under the data protection law, what we have, if we try to look at legal techniques that have been used in data protection law in many jurisdictions around the world. Firstly, of course, imposing the general rules that every personal data should be protected, right? But there we still have some discretion, some room for interpretation. What is personal data? How the personal data should be protected? There it is still under the discretion of each actors or players in the environment. Secondly, so data protection law also set some prohibitive or instructive specific rules, such as the purpose limitation principle, or the many other principles that, for example, the data must be accurate, the data subject should have the right to access those data. So these are the rules that we have in almost every jurisdiction. But still, we have different interpretation of each rule in different society. So what about changing architecture? Can the data protection law change the architecture of data protection or the process of data today? I could not find any example of the law that trying to change the architecture itself. So if you can think of one, please let me know. Because I believe that actually the structure of the technology of using data today, they are no longer, or they never been in hands of state control. So it is in the private sector and also in the hand of engineer or scientists rather than the hand of state from the beginning. That's what I believe, but if you have other example, please let me know. Okay, so then data protection law come to the reason and the most used way to control individuals' behavior in data protection environment. So it obliges private company and also other public institutions, public organizations as well, the rules and guidelines of technology that will be used to protect data, such as encryption, anonymization, de-identification, pseudonymization, depend on what law you look at, depend on what technique you look at. You want to add something? Okay. Okay, so here, I want to make some point here before we look to, Okay, before we look at further specific rules. So when we talk about data protection, we talk about the right to privacy, but I think one thing that we need to make it clear here is that the right to the protection of personal data, or even the right to privacy itself, is not an absolute right. So it must be considered in relation to its function, so how we use the data, how it can be useful for many sectors, medical, education, or many others in society, and must be balanced against other fundamental rights. So it is not only the data protection, it is not only the right to privacy, it can be the freedom of expression, it can be the freedom of religion or other things as well that might be in conflict with the data protection. And also, the other principle that we need to take into account is the principle of proportionality. So the law cannot protect personal data without considering other important factors, and also cannot do it in the way that improportionate when you compare with the benefits of the individual, the protected individual. So this is an excerpt from GDPR, General Data Protection Regulation of the EU, Recital 4, which remind us to think about data in the way that actually it is not absolute. So it's come to actually what Kun Atit has, I think, told us in the beginning, that so we need to find a way to maximize.
You are not here at the beginning.
I think I know. Okay. So okay. So we need to find a way how to maximize the data protection, but at the same time, how to minimize the burden of relevant actors. Okay. So we have legal issues. We have some legal issues here. The first of all, what is personal data? So of course, if it is not, if a set of data or information is not personal data, it falls out of the scope of application of many data protection law in this world, including the EU's GDPR as well. So if a set of data is not personal data, it must be treated as the other. The data protection principles will not apply. And also, so we look at, so I would like you to look at each of categorized group of data, which actually it can be overlap as well. Okay, first of all, encrypted data. The data that is already encrypted by some method, I think, okay. So this is definitely personal data. So encryption is one of an appropriate safeguards to protect personal data, but by encryption, it doesn't make that data become non-personal data, which means even encrypted, still the data must be treated under the principle of data protection. Okay, but by the method of encryption, that set of data can become anonymous or synonymized data. So this will create some gray area within the application of law. Okay, next one, anonymous data. In many law, I think I didn't find any law that say anonymous data is personal data, but so in GDPR and also in many other jurisdictions, anonymous data is not considered as personal data. However, the non-identifiable data, so here we need to be careful with the use of word here. Non-identifiable data with possible of becoming identifiable data later if it is associated or combined with other information, such as the one that we see in Kun Chakapong's presentation. That is very very good example of at the presence, at the appearance, it might look like an anonymous data. You cannot identify the person, but with the other existing information, we can identify someone from that data. So here, it is very difficult. We have the difficult problem here is that some data, how can we know that what kind of related information exists out there in the world? So many data controllers.
Now or the future as well.
Right, now and the future as well. Even now, each data controller, they have different potentials. They have different capacity depending on the technology they have, depending on the personal, the human resource they have. So some can de-anonymize, some cannot. So we have within the debate of these anonymous data, we have the absolute approach, which say if there is, even in theory, some way to re-identify that data is definitely personal data under the protection of data protection law. But in the relevant approach, we have other approaches as well. In relevant approach, they consider more the burden or the practical reality of technology at that time, or even the potentials or the capacity of data controller or data processor. If we consider those contexts, actually those who support the relative approach will say that we need to look at each data controller capacity and environment of technology at that time to identify if it can be anonymous, it can stay as anonymous data or not. So this is the big gray area and the big debate among many experts, lawyers, and engineers there. So some example here, the dynamic IP address that this case went to ECJ last year, that the Advocate General of the ECJ and the court itself, they have different opinion there. So we have to follow the court opinions, but also the Advocate General opinions was also considered as important one. So the court took the position of absolute approach, that if it can be, even in theory, combined with the other data and re-identify, that data is definitely personal data. But the court at the end of the judgment that even if we have the wide scope of application of personal data, still it doesn't mean that every personal data cannot be processed without consent. There are many exceptions, such as many other legitimate interests, such as fraud detection or other legitimate reasons that can be exception of processing data without consent. So we need to separate two issues. So the first one is what is the personal data? And the second one is how we deal with that personal data. Is there any exception? So they must be treated separately, okay? So the next one, the pseudonymized data is a technical term recognized in the GDPR itself. So even it is pseudonymized, still it is personal data. Okay. Okay. Okay, and lastly, statistic data. If you can make sure that no one can identify from that statistic data, so it is not. But with some exceptions. For example, for some particular disease, if there is only one person in that country who has that disease, definitely you need to delete that data from the set of the whole set of data. And this one is established as rule in Japanese law already. So we know that the Japanese law has changed last year and become effective this year, that they try to set some standards to use the big data without consent, but with the many means of anonymization or pseudonymization. So these are, what you see here are the list of factors, character, number, letter, symbols, or anything that can identify a person. You must delete all of these data from the set of big data. Okay, so should I stop here? Right.
Yeah, then we'll come back later.
Okay.
So, because I think we talk a lot about this de-identification, re-identification, right? An example from different parts of the world, right? And also you're talking about the balance, right? Because a lot of people are talking about yes, actually data, big data can be used for innovation, for a better public policy, for a better life of human being, right? As Kun Jakkapong also say as well. I think maybe on the panel we have a little bit more concrete, partly technical, also public policy as well. Example from Taiwan, right? And I think I'll introduce you to put it further from that, please. Yeah. ขอสไลด์ 3 ครับ
Actually, in Taiwan, we enforce the personal data protection law since 2012. And under such kind of legal framework, that everyone that intentionally or unintentionally leak personal data they collect to third party, they have to face criminal charge. And in the other way, they have to pay some fine. And for every one record, they have to pay $500. So after we enforce such kind of legal framework, that many government officers they don't want to release data to industry, because we know that in the era of big data, data itself has a lot of value. Data can be released to third party, released to academic, that for research, then we can find very large potential value of data. But in the same time, we have to consider about how to release data without violate the personal data protection law. And so, some speaker just mentioned that there are some gray area that what is a personal data, what is not personal data. Actually, in current legal framework, it is in Taiwan, there is no formal definition. What is personal data, what is not personal data? It only says that the data can be directly linked to personal information, it's personal data. But what kind of data? If we encrypt data, or if we make data anonymous, but in some sense it can be re-identification later. So we need some standard to make the definition for the personal information. So starting from 3 years ago, the government started to set up some standard. Actually, we already have the global standard. It's an ISO 29100 and ISO 29191. So based on these two ISO standard, in Taiwan we have the CNS. The CNS stands for Chinese National Standard. CNS 29100 and CNS 29191. In this standard, we define some process. If an organization wants to release data to third party, what kind of process they should follow? So first of all, they should define their risk and what kind of data they want to release, and what kind of attack they have to face. And after that, they have to describe what kind of mechanism they use to identify the data. So it's sometimes a process. It's a standard for process, not for technical, but for process. So in Taiwan, the government, we set up the accreditation standard that follow the national ISO standards. And in the other way, we have some control process. There's also reference to ISO 29 and 101 standard. So there's a control process. It's a more detailed description of how to do that. And we also have some kind of guideline, some kind of framework and guideline, and for the government and for the company to follow. And after that, we have two systems. The first system is that we have the accredited organization. We set up the process according to the mission and the business requirement of the company. And we help the company to define their data and define their process. And we help the company to go through the whole process. And in the other way, there is some accreditation organization. They will check if your process comply with the national standard or international standard. And after they confirm that your process was compliant with the national standard, then they will issue the certificate to the organization. So that the system we already set up in Taiwan. And under such kind of system, what kind of technology we use? Currently, we use several different technologies to do the data de-identification. So the most straightforward way is just data sampling. It's very straightforward. Just make some average of the data. And the second one is K-series. Dr. Jacopon just mentioned that it's try to make data cannot be reversed to link to the original data by making the data more in some way that making the data be not so easy to be traced back. And we also have some other mechanisms, such as this is also a very traditional technology, statistical disclosure control. It was developed by the statistics academy. It's also maybe a technology more than 40 years. And we also have another technology called differential privacy. Under such kind of technology, we can add noise to the data. So
can you explain that a bit? Differential privacy, what's that?
For differential privacy, that we just try to add noise to the data and try to make data more
obfuscation.
Yeah,
right,
yeah,
okay.
yeah. But because for sampling and K-anonymous and for SDC, we only sample the data. But for differential privacy, we can add noise, add some other data, add some other record to the data.
To make it more difficult to re-identify a person, okay.
Yeah. And we also, actually we also have developed some crypto methodology. But actually, cryptography cannot contribute to the identification too much, because the most state-of-art technology is called homocryptography, but it's very difficult and it's very computational. It spends a lot of computational resources. So actually, we are still studying if such kind of technology can be applied to physical deployment of the data process. So right now, actually, according to our standard, right now, actually, the K-series is the most feasible and the most practical method to do the data de-identification. And so this is our current status of under such kind of standard and such kind of technology. Right now, we have 2 ministries already adopt such kind of standard and technology. The first one is Ministry of Finance. They adopt the national standard and also the K-anonymous technology to deal with the tax income statistic. And after they use they adopt standard, they can just provide the tax income statistic to third party for research. And the second one is the most important one, is the Ministry of Health and Welfare. They have the medical data and also social affairs data. So right now they have adopted the national standard and also the K-anonymous technology to their social welfare statistic. And right now we are working on the national health insurance data, because it's a very big database. In Taiwan, we have national health insurance for every people. So actually, it has the health record of every citizen. So, but actually, the database, a lot of academic researchers, they want to use such kind of data to do research, but they are civil society just against the government to release the data to third party. So right now, we are helping the Ministry of Health and Affairs to adopt the national standard and also adopt the K-anonymous technology in such a way that they can convince the civil society that the data released to third party is secure. But we can, as just the speaker said, that we cannot make sure 100% that the data can be reversed back to the original data. But we can say that we do our best we adopt the standard, national standard, and we adopt the state-of-the-art technology. And we do our duty that to make the data cannot be reversed back. And we hope we can release such kind of data to academic to have its potential value. And we also support the government data marketplace in Taiwan. And we try to set up a government data marketplace. And every ministry can contribute their data to the marketplace. And the academic or industry can just apply for the research project. And once the project was approved, they can just go to the marketplace and they can just collect government data to do their project. And right now we are also with telecom communication and financial holding company. They also have a lot of data, and they also want to provide their data to third party. So we are now we are working with telecommunication and the financial holding company to adopt the national standard and also the technology, such that they can just release their data to third party. So that's the brief of the current status of data privacy in Taiwan. Thank you.
Thanks a lot. So I think something in common that we hear from this panel, it's like at least like say taking example of this like public policy decision, like for example this like there's a lot of example from the medical, right, or the public health, right. Without the data, the government cannot justify where to use their limited resources, right, to build say like new hospital, like where they are needed the most, right. So, but then again, that's a question of the protection of personal data, right? So the techniques like data masking that Jakapong talking about is like, okay, well, actually, in order to decide about where to build a new hospital, you don't actually have to know the exact age of a person in that province. All you need to know is probably the range, right, of the age of people in that province. So by these techniques, the data available will still useful for making public policy decision, but will not be able to identify a particular person, right? Or in the case of like talking about the differential privacy, right, that you mentioned, it's like, so putting a lot of noise, right? But in a manner like those new records that are added to the database will still, in total, right, it will still reflect the same statistical attributes, right? So for example, like if the database say have like 60% female and 40% male, those noise should be the same percentage as well, and you add this noise into the database to make it more difficult to re-identify people. So that's the idea. I think I like to take something like from the floor, and probably we have like more comments from our colleagues. Can you like to join Mubashi? You like to? Okay, that's fine. And anyone like to take any like comments or questions or whatever? Yes, please. Actually, that's one.
My name is Ken Ying. I'm a lawyer from Taiwan, and I formed the Data Protection Practice Group at D&D since 2012, when the Taiwan Personal Data Protection Act was amended, significantly amended at that time. So I want to share some experience for Taiwan. For example, what Dr. Huang said about criminal liability, it was criticized a lot because if you negligently disclose personal data to someone else, should you be held criminally liable? So it has attracted a huge debate in Taiwan, and the law has been amended and effective since March 2016. Now you will only be held criminally liable if you intentionally breach data, or if you want to make some profit or gain some illegal benefit, then you will be held criminally liable. And I want to share one recent case. A Supreme Court made a decision in January this year. It was about our health insurance record. Taiwan has the famous health insurance system, and the system protects all of our health, and also it collects all the data of Taiwanese. And the government actually opened the data to all the research institutions for them to study medical issues or improve health. But before the government released the data was encrypted. So for the government, they think that they are not releasing personal data because the data was encrypted, and the research institution does not know who the individual are. But Human Rights Society, I think there was one member attending this forum. They think that's not right, so eight individuals filed a lawsuit against the government to prohibit the release of data to the research institute. So the Supreme Court made the final decision on that issue. There are two major results that I can share. First of all, regarding whether encrypted data should be deemed as personal data, the case is that the data was transferred between two different government agencies, and before the data was transferred, the data was encrypted. So supposedly the second government agency shouldn't know the identity of the individuals. But the problem is they are common staff among the agency, and that common staff hold the key of the encryption. So the Supreme Court says that if they are smarter, then the receiver of the data wouldn't have been receiving any personal data because the data has been encrypted. So that's what the judge said. And from the court decision, we can tell that if the data has been successfully encrypted and the receiver is unable to unlock the data, then the judge would think the data is not personal data and can be used and forwarded. That's one implication from the judgment. And another one is, I think what the other Taiwanese would be criticizing our government, because under our current Personal Data Protection Act, the government has a wide range of power to use personal data. As long as it is within its statutory power, it can collect and use personal data. But the government can change its statutory power at any time, and they can interpret it as broad as possible. So that's the second range of it. And the judge thinks that for the Ministry of Welfare and Health, they are protecting the benefit of the whole society. The judge actually encouraged the flow of the data. They want more researcher to research the data and obtain benefit result for all human beings. So actually the judge said that if possible, we shall allow the data to be released and to be further used. So that's something I can share from Taiwan. And what bothers Taiwanese, I think under our law, we distinguish personal data as two kinds. One is you can identify an individual directly. That's the easy one. And then another set is the difficult one. That is, if you can use the data indirectly, identify anyone, that data is also personal data. For the second one, there is no explicit standard how to determine that, and it's actually changing for different people. The data collector and the data receiver, because they have different ability to cross-check different database. So the same set of data may be personal data to one group of people, but maybe not for another group of people. So that's another thing that's affecting the interpretation of Taiwan Personal Data Protection Act. So I think the second one is what this forum want to find out, how to determine what kind of data can be used to indirectly identify a person, and what kind of data cannot. And I think that's something technology can help us. Thank you.
Sure, thanks.
Can I ask a little bit for some information? This is very helpful for me as well as a lawyer. So when you said the criminal liability, you said it must be intentional and with the purpose of gaining profit. So they are the two criteria of establishing criminal liability, or they are separate?
Actually, you need to, that's the whole set.
Okay.
You have the intention to gain improper benefits.
Okay.
And it's more than just willful. You need to have certain intention to do something.
Okay. So if someone intend to release data, to breach data, but without any benefits, but without any commercial benefits, like just to bully someone, would that be counted as criminal liability under this law?
There's another one that damage another person's
Okay.
rights. So
Okay.
that would be the second category.
Okay. Thank you.
Civil law list.
Yes, of course.
It's not criminal law.
Microphone, please.
pay the money.
Okay.
One week.
So it can be also under the civil law,
Yeah.
the usual category as well.
Yes, please. And yeah, and you next.
Al from Philippines, FFA. First, clarification on the Taiwan case, because on the presentation, I'm very impressed because it seems that across government as an enterprise, there is an appreciation, and all agencies are marching in step that data has to be protected. Because unfortunately, that's probably the exception in our country, in the Philippines. It's a new law, aside from lack of awareness of all these things. There is also different, different interests at play. So, the National Privacy Commission, we have one of their officers here. That's one of the tasks, to sort of get people from different agencies to march in step. So, how were you able to achieve that sort of general strategic sort of agreement that we should de-identify? Because that is not an easy thing to do in our experience. That's the comment in question. And I guess a suggestion, a positive, so we don't feel that everything's negative in the Philippines, that the health sector is a bit advanced in our country, in the sense that the health insurance community has been meeting since before and was ahead of the national. And a possible model that we could throw into the discussion is the idea of sectoral privacy codes, where, because there are just simply different domains that not all are familiar with. So in the health and medical domain, there are specific sensitive information that only health professionals will understand as such. So there have to be developed, we cannot assign that all of these things in different sectors to the National Privacy Commission. So we feel that a multi-stakeholder approach is better, where it's multi-stakeholder in terms of the sectors develop their own rules and standards.
Okay.
But within the sectors, there's also multi-stakeholder representation in what eventually should be a privacy board, a health privacy board, national health privacy board. What we have now is a sort of a advisory experts group, which hopefully we want to convert into a national health privacy board. So I just want to throw that in the context of government does not always march to the same drum,
Sure.
especially in such an important issue like this.
Okay. Can we go to the second questions and then back to the panel?
I would
please?
like to just add one thing to Al, is that some trend in the law, in the data protection law, is that what we see before, there were more sectoral law, but right now many countries change to the general protection.
Okay.
So I think that should answer you as well.
Okay, please.
Yes, hello, I'm Vera Ritter from Hong Kong and from Open Data Hong Kong. And I wanted to talk to from all panelists, how do you see this relationship between data privacy and data innovation? Because that is, I mean, if you are in startup circles in everywhere, they are very data hungry companies, most of them, and they always assume the data they use is their asset and their IP in a way. And so I wonder also in this whole context of smart city and so on, it is a lot of data intensive discussions. So I like your idea about the data marketplace of the government. You have open data, but you also have the privacy very strong. So, and then I thought about this idea about architecture and privacy by design. Could we have more innovation in this field? And you said you have no example for data privacy by architecture. But if I think about the car drivers, the most effective way is actually to have these bumps in the road. That's the only way really to prevent them. So I was thinking we need to find something drastic like this for the industry, for the designers and for the software developers. So what can we think about? Thanks.
Okay, I answered. Maybe I cannot answer your question, but I think that's the balance is very important. because what I'm trying to say is not, we shouldn't have the mindset like we cannot release the data. That's very dangerous, right? Because otherwise we cannot use anything. Because one thing that Huang talked about is, okay, I touched that point. They differentiate privacy, right? The concept has been introduced like many years ago. When we trying to add some noise or even trying to synthesize the new data from the original data, it seems to be more safe to people, right? It means that we don't release the actual data, we release only syntactic data. That I think one of the maybe challenging problem, I mean the problem of that approach is, suppose that someone used noise, added data to do something, for example, in their startup, right? Can we guarantee the success of the data crunching, the result? I mean, that could be a bad thing for the company as well. If we use that data to do something, but we try, for example, we try to predict behavior of our customers, I think we should somehow protect the private sector as well. So I think that the key is to balance on this topic, not to trying to only protect the data.
Actually, if it's possible to move to my slides. So actually, what I meant by saying that, I could not think about the example that the state or the state law itself changed the actual architectures. That I think even privacy by design, it must be done by many actors, by many players in the industry, not by the state law alone, because we know the state cannot control the set of data or even the internet itself. Okay, but that can I move to the issue of encryption? And yes, privacy by design is one thing that we should consider as the guideline or even becoming the new data protection principle for many stakeholders. And when we think about encryption, I would like to put to another legal issue here is that how do we assess if an encryption sufficient to protect data? So there are many elements that maybe you can add more here, but what I can identify from at least from GDPR as the strength of the encryption algorithm. So this one is definitely depending on the technology itself. Second, the length of the encryption key, but I don't know in the future would this be one element enough or not. Okay, and of course the other element that many forget is the security of the key management. So this is not only about the technology itself, but it's also about the management system, the privacy policy within the organization. And this, go back to the Taiwanese lawyer, that the example that you provide before, that actually if you have the same person holding the key in overlapping organizations, would that be the good management or not? And another problem from that example is that even if that person holds the key, so that person will legally be able to access the key when that person acts on behalf of one organization, right? But on behalf of the other organization, that access will be considered illegal. And now, even within the GDPR, we have the debate that should we consider the illegal access as one element to assess the risk of data of encryption, of decryption as well. And of course, that leads to another issue of possibility of the future development of decryption. This is also the principle established by the Data Protection Directive of EU in Article 29, that we cannot only consider the current one, but also the future. So some propose that actually, so if we produce an encrypted set of data and we intend to use this for 10 years, but in the 9th year that the encryption technology has developed, so that in that 9th year, within the first 9 years, the data was completely anonymized. So it can be considered as anonymous data, so it does not fall into the protection, the data protection principle, the data protection law. But after the 9th year, when the technology has developed, it must be reviewed and considered as personal data. Okay, so I would like to quote this one from another law professor, that due to the technical development, the encrypted data will only be anonymous for a certain period of time, as I used in my example before, and thus the level of encryption has to be checked constantly by the controller, not by the law enforcer, but by the controller themselves, and not only when the controller processes the data for the first time, so it must be reviewed over the time, and these can be considered as quite a big burden for
controller.
the controller.
Do you like to have any response, Huang?
Can I have a question?
Sure.
Because
also, the panel is going to ask each other now.
Right.
Okay.
Because I think in general,
Relax.
when you're trying to protect something, I mean, in terms of data privacy, right? It seems to me that our approach, I mean, around the world is to have very general law, and then the set of practices could be updated regularly by the state or something like that. Is it always the case in Taiwan as well?
Like sunset provision in the states, right? That like required, like, okay, by like 5 or 10 years, you should review. Yeah.
For the national standard, generally in the standard process, for the certificate, you have to renew it every 2 or 3 years. If the whole process comply with the standard, and even the standard itself will be revised. So if the standard is revised, you have to check the process again.
Not the law, right?
It's only a national standard. It's not the law. And secondly, in our experience, most of the data usage is only project-based. So the project only maybe 2 or 3 years. And after the project ends, then the data should be deleted, should be removed, totally removed. So for the problem equation, I think in our experience, it should not be too, there's no right now, it's not too big problem for data equation. And in response to the audience, that how can we do that? That actually what we have to do is still far behind the expectation of the civil society, and the industry still think we should move more aggressively. But right now, what we can have a national standard, and we have some kind of mechanism. I think there are 2 important driving forces. The first one is that 2 years ago we have a very top-down policy, that we have a premier come from Google, and he realized the value of data. So he just said some ministry discussion, how to set up standard and how to assign the duty to the ministry. You have to do that, and so it's a cross-ministry collaboration to achieve this. And secondly, in the team that actually the team includes the technical and also the legal staff, and also include other domain-specific experts. For example, when we are dealing with the financial data, the tax data, then we should have some expert from tax financial expert, and we are dealing with the healthcare data, which includes some expert from medical industry. So it's I think the domain collaboration is very important for data.
Thanks. I just want to check with the remote participant. Does there any question? There's no, right? Okay, 2 questions from here, please, and probably we have to wrap up. Probably you first, right? Okay. Yeah, here and here.
Yes. I am Michael Skilstad from Chulalongkorn University, but originally from Norway. I have a question. Is there anything that could prevent a government agency from using big data to monitor individual students' behavior to oppose or to prevent terrorism or even political opposition? I have an article here from Saudi Arabia, big data analytics for behavior monitoring of students.
I think as far as the Philippines goes, I think I can answer that. So National Privacy Commission of the Philippines. In our jurisdiction, if whatever your governmental purpose is, there's an exception for that governmental purpose. The moment you stray from that purpose, then you're not covered under the exception provision, and you have to be able to demonstrate consent. If you don't have consent and you still process it for that unauthorized purpose, then there's criminal liability. We talked about earlier about the difference between the absolute approach when it comes to personal data and the relative approach. And it seems that in the personal approach, then the distinction on whether encrypted data is personal data becomes irrelevant, because then, do you see the trend in other jurisdictions moving toward a relative approach, or are because the ECJ decision came out last year, do you see benches moving toward an absolute approach?
So I think for ECJ, and ECJ is quite clear that they took the absolute approach, but that before the GDPR became effective. And if we analyze the GDPR, which is very, very complicated, we can see both absolute approach and relative approach there. I think, I'm not quite sure, I do not have the actual answer to that, but if you look at many other jurisdictions, I think many governments, which those who are quite keen to encourage private sectors to use more data, to have more innovations, they try to facilitate the use of data and try not to drop the encrypted data out of the personal data, but try to make it some rules, but more more flexible rules for them. Like if we take the Japanese example, so they have kind of the guidelines that what kind of data that you must delete it, and if you delete, okay, you can use it freely, but it doesn't mean that you are not subject to the data protection law anyway. So I think maybe we can go back to the ECJ decision in the sense that even though the data protection law has a wide scope, wide material scope, both in the territoriality and also by the content, still there are some exceptions, and if you can prove that you follow the standards and has the legitimate reason, still you can use the data. It doesn't mean that labeling the data as personal data means you cannot use it in more productive way.
I think we have like 5 minutes here. Any remarks, comments, observations? If not, probably I will pass back to the panelists to probably some last words before we go back to the closing, right? Closing now, right? The plenary. Oh, that's one, right? Okay, I'm sorry. Please.
I just have a comment. This year, for the Privacy Commissioner Conference, the international one, is happening in Hong Kong in September. Maybe for those of you who know. And I think it's a really a very big conference of all the international privacy and data commissioners of the world, from the governments and so on. So maybe quite interesting for civil society to observe. And
Yes.
there's also the University of Hong Kong is also having a Asia Privacy Scholars Conference. So it's maybe,
Yeah.
so a lot of things happening if you are interested in
Yeah.
this field.
Sure.
So you know
that's,
about it
yeah,
already.
that's very important, Joseph. And apart from, of course, like IGF, right, and regional global one, there's actually a lot of venues that people discuss about it. The Commissioner Conference, the Scholars, and also AIPP, the International Association of Privacy Practitioners. I think like just this week, right, have a conference in Singapore as well. Yeah, IIPP, right? So like that's our venues that like we can actually like explore more as well and have some discussion cross the circles, right? So anything like as a final remarks from our panelists, please.
I have some another point to make since we talk about the general law or sectoral law there. Another remark here is that this might be one of local concerns because Thailand is one of the countries in this region that could not develop a general law for the data protection, even though we try for more than 10 years now. So the problem here is that even in the countries where the government could not develop the general law, still many sectors, many industries, they still need some rules for data protection because actually the data protection standard is imposed from the West. Actually, like we see in the EU, GDPR is trying to extend the scope of application to any data protection happen in any country in the world if the data subjects, they are European citizens. So we see these things imposing. So many industry will develop their own rules. And then we have the sectoral rules anyway, like what happened in Thailand, some financial sector trying to develop their own rules. And then we might see some discriminatory effect happens in many in the country. That is one point. Okay. What was the question again? The monitoring of students. I think that go back to the Taiwanese case again, that when you have this exception in every data privacy law, that if it is required by law, if it is required by the police or regulatory law enforcement, every principle can be exempted. So that is the flaw in the law itself, and those one who have power to abuse this flaw, they are the governments. So what might be something to convince the government not to put that kind of backdoor or that kind of flaws in the law is is the exception, is the example of what we had in the U.S. EU. The safe harbor principle, the safe harbor agreement that has been considered as illegal under EU law by the European Court of Justice, and then which makes all the American private sector's effort to achieve the data protection level become meaningless just because of the government backdoor, the government effort to abuse those flaw in the law. And then this is the power play between the American and the European. But what we can benefit from here is that telling our government that anyway your industries must sell and buy things from the European, you want the European customers. In that sense, if you put that kind of flaws or that kind of backdoor in your own law, what happens is you will be considered as the countries operating with the low data protection level. And then the national law or all the guidelines that you try to issue will be meaningless. So that might be one thing. Any other? Okay, yeah.
One last thing. Statistic data is not safe. I have to say that. I mean, no, I mean, because we are going to publish an article to say that even under the statistic data framework, you can get only average, maximum and minimum. We still can track back to the original of it.
Thanks Hong, Unjakapong and Titirat, and thanks for all the participants here in the room and the remote participant as well. That's it for this panel. Hope, and if you have any comments on this, I'd like to reflect back to the maybe probably in the synthesis document regarding the discussion in this room, you are very welcome. Go to that comment.rigf.asia. Thanks all. Sure.